Hey, D. Kumar here from Host Group Real Estate Academy and RE License Pro. I am super excited to be here. Let's get into it. 20 Massachusetts questions to help your minds get oriented with this examination coming up. And I look forward to y'all passing your examinations, and I hope these questions are super helpful. All right, question number 1. The requirements to become an appraiser in Massachusetts include, letter A, completing a 40-hour pre-licensing course and passing 2-part examination. Letter B, holding a valid real estate broker license plus a 1,500 hours of appraisal experience. Letter C, a 75-hour course for a trainee license and a 150-hour course to become a licensed appraiser. Letter D, a 75-hour course plus a 2-part state exam for a trainee's license and a 150-hour course for an appraiser's license with no exam. Once again, question number 1, the requirements to become an appraiser here in Massachusetts include, and the answer is letter C, a 75-hour course for a trainee's license and a 150-hour course to become a licensed appraiser. All right, so sometimes on examinations, they do want us to know what it takes to become a licensed appraiser. One of the reasons why is because brokers and real estate salespersons can conduct a valuation known as a competitive market analysis or a broker price opinion. They can never call it an appraiser unless they're a licensed appraiser. So understanding and knowing some of the appraisal requirements and what it takes to be licensed here in the Commonwealth of Mass is useful, and you sometimes see these all over practice examinations, which leads me to believe that there could be some basic questions on what it takes to be licensed as an appraiser. Question number 2. An owner who loses their property to a tax sale generally has how many days after the sale to reclaim the property? Letter A, 30 days. Letter B, 60 days. Letter C, 6 months. Letter D, a property cannot be reclaimed after a tax sale, only before the tax sale. Question number 2, an owner who loses their property to a tax sale generally has how many days after the tax sale to reclaim the property? And the answer is, boom, 6 months. So we're going to be learning about things called the statutory right of redemption or the equitable right of redemption when it comes down to a tax sale. So tax sales are covered. Typically, depending on the books or the courses that you're taking, you might see it in the real estate taxation section. That could be it, or the ad valorem tax section or something like that. So you'll see it somewhere there. So here in Massachusetts, we have something called the 6-month statutory right of redemption on a tax sale, which gives the delinquent taxpayer, even if they lose their property at a tax auction, they have 6 months to be able to pay any back taxes, penalties, and fees owed or interest to the highest bidder at the tax auction to reconcile and maintain their title. So it's called the 6-month statutory meaning by law right of redemption. Everybody has the equitable right of redemption, which means up until the auction, if you can get back, current on the delinquent taxes, then you're good. So that's just a question on tax sales and tax liability. Question number 3. Which of the following is true regarding a tenant's security deposit? Letter A, it must be returned with interest within 7 days of the end of the lease agreement. Letter B, it must be returned with interest within 30 days of the end of the lease agreement. Letter C, it must be returned without interest within 7 days of the end of the lease agreement. Or letter D, it must be returned without interest within 30 days of the end of the lease agreement. Question number 3, which of the following is true regarding a tenant's security deposit? And the answer is Letter B, it must be returned with interest within 30 days of the end of a lease agreement. Okay, so in this particular question, we saw a couple of different things. Number one, we saw these sort of conflicting pairs. We saw letter A and saying 7 days at the end with interest, right? And then letter B, it said with interest within 30 days. And then letter C and letter D were very similarly written, but without interest within 7 days, and again within 30 days respectively, right? So the underlying things were without interest, with interest, and then within 7 days or within 30 days. So which of the following is true regarding a tenant's security deposit? We definitely want to know what landlord-tenant rules and regulations are. You're going to see that here in Massachusetts. In most states, again, I would suspect that you're going to see landlord-tenant rules and regulations because leasing is a big fundamental piece of brokerage. So you're going to want to know that. And here in Massachusetts, security deposits must bear interest. They must gain interest on the account. So number one, with interest. And number two, they have to be returned within 30 days of the last day that the lease expires. So at the end of the lease agreement, within 30 days there, not within 7, within 30. Okay, so 7 days is as information that's just incorrect. Without interest is also incorrect. So we can eliminate C, we can eliminate D. 30 days is correct here, but not without interest. And the only acceptable answer here would be letter B. It must be returned with interest within 30 days of the end of the lease agreement. Question number 4. In order for a corporation to obtain a corporate broker license, which of the following is true? Letter A. All of the partners must first obtain a real estate broker's license. Letter B. At least one of the partners must hold a real estate broker license. Letter C. At least one of the partners must hold a real estate broker's license, and the other partners must all have salesperson's licenses. Or letter D, every partner must have an individual broker's surety bond. In order for a corporation to obtain a corporate broker's license, which of the following is true? And the answer is letter B, at least one of the partners must hold a real estate broker's license. So this goes to the topic of, can an artificial entity be licensed? And the answer is yes here in Massachusetts. It can be a corporation, it can be a partnership, it could be an LLC, right? So it could be an LLP. All of which can be licensed here to do business as a broker. If it's an LLC, the LLC needs to carry things like general liability insurance, etc. So all of those things are established and set as the statute reads. Now, any of these artificial entities must have a human being that has a broker's license. That human being is assigned as the principal broker, and they are identified with the state as being connected to that particular corporation. So it's not very hard to do this, but in order for a corporation to make representations, to pretend that they're a brokerage company or anything else, they need to have a broker's license. The only way that the entity can get it is if one human holds a license called the principal broker of the business. And that's what you need to know about that. Okay. So going back to this, at least one of the partners only needs to hold a real estate broker's license. And that's what you really want to remember when it comes down to these types of corporate broker licensing questions that are very popular, that you do sometimes see on practice exams through and throughout. Question number 5. Which of the following claims cannot be made under Mass General Law, Chapter 93A? Letter A, a business filing a claim against a business. Letter B, a consumer filing a claim against a business. Letter C, a business filing a claim against another consumer. Or letter D, a seller filing a claim against the listing broker. Question number 5, which of the following claims cannot be made under Mass General Law, Chapter 93A? And the answer is Letter C, a business filing a claim against a consumer. All right, so 93A is going to be on real estate sections for the Massachusetts examination. You're going to see it. It's Chapter 93A, also known as the Consumer Protection Act. This is definitely on there. You've, at this point now, if you've gotten to know me, now know that I will definitely drone on about that. It's on there, it's on there, it's on there. So you definitely need to know different little things about 93A for sure. One of which happens to be that 93A is one of those things where we can sue, a business can sue another business. Okay, a consumer can sue a business under 93A, and however, a business filing a claim against a consumer, you cannot use a Mass General Law Chapter 93A. So it's business to business and consumer to business, and that's it. But a business cannot sue a consumer using 93A. Another thing to remember is a seller cannot sue a buyer, or a buyer cannot sue a seller using 93A. They can sue each other for other reasons, but they cannot use the Consumer Protection Act to sue each other. And then letter D here is a seller filing a claim against a listing broker. Yes, you absolutely can use 93A for that. So letter A, B, and D are all instances that we can use 93A, and letter C is not. And again, remember, be careful here. Cannot be made under 93A. So you have to read this very carefully. Otherwise, some students might get tripped up here with those little words and phrases. Question number 6. Which of the following must be disclosed in writing by a listing agent? Letter A, if they have a personal interest in the property. Letter B, if the home came back on the market due to the previous buyer's inability to obtain financing. Letter C, if the home was the scene of a highly publicized murder-suicide. Or letter D, all of the above. Question number 6, which of the following must be disclosed in writing by a listing agent? And the answer is letter A, if they have a personal interest in the property. So kind of knowing when we have to disclose certain things, specifically in this question was in writing, is going to be pretty important. And as we kind of go back, certain things, like if they have a personal interest, if a real estate licensee has a personal interest in a parcel of property, it has to be disclosed. And it has to be disclosed in writing. But if the home came back on the market due to the previous buyer's inability to obtain financing, yeah, it sounds good, but that's not true. I don't have to say to anybody else that the former buyer that was looking to buy the property couldn't get the mortgage or a mortgage loan for that. I don't have to tell anybody that in writing. If the home was a scene of a highly publicized murder-suicide, so that was back to that catch-all of stigmatized or psychologically impacted property conditions. Remember, we do need to know what those are. Those are things that society has branded as undesirable for alleged hauntings, criminal issues, murders, suicides, those types of things. And remember the HIV/AIDS question when it comes down to psychologically impacted property conditions. Look back at your chapters there. But all of those don't have to be disclosed in writing here in Massachusetts. Only if you know do you have to answer that truthfully, but not in writing. So again, one of the operative phrases here of this question was things that need to be disclosed in writing. And then all of the above would obviously be incorrect. So A here, if they have a personal interest in the property regarding the listing agent. Question number 7. What does the acronym MUETA stand for? M-U-E-T-A. Letter A, Managing Underground Environmental Tanks Alliance. Letter B, Massachusetts Uniform Estate Trust Accounts. Letter C, Massachusetts Universal Estate Transaction Association. Or letter D, Massachusetts Uniform Electronic Transactions Act. Question number 7. What does the acronym MUETA stand for? And the answer is letter D, the Massachusetts Uniform Electronic Transactions Act. Okay, so here really quickly, we just want to remember that electronic transactions are enforceable here in the Commonwealth of Massachusetts. And in order to make these things enforceable, we need to have law that allows for these things to be acknowledged and recognized under certain conditions and terms, and have certain requirements and makeups and markups. So we want to make sure that we understand that here in Massachusetts, electronic transactions, signing contracts, signing leases, signing disclosures, all of that stuff electronically is absolutely fine. And the law that allows us to do that is, the acronym is MUETA. It stands for the Massachusetts, M for Massachusetts, Uniform Electronic Transactions Act. And this allows for electronic transactions to be rendered enforceable here in the Commonwealth of Massachusetts. Question number 8. Military veterans are protected under... Letter A, the Massachusetts Fair Housing Laws only. Letter B, the federal fair housing laws only. Letter C, both Massachusetts fair housing laws and federal fair housing laws. Letter D, neither Massachusetts fair housing laws and the federal fair housing laws. Question number 8, military veterans are protected under... And the answer is... Letter A, the Massachusetts Fair Housing Laws only. Okay, questions like this are wonderfully classic, and I'll tell you why, is because the student is typically thinking, hey, military veterans, any protected class, I would figure to go err on the side of caution that they're protected under all federal and state law. Incorrect. So there is no state class, protected class under military status. There's not. There's only 7 protected classes. So we still only have 7 federal protected classes, and military and veteran status is not one. However, the state of Massachusetts does have that as a unique protected class. So you want to remember your protected classes. You want to know the differences between state and federal law when it comes down to fair housing. You definitely want to know those for this examination. I'm going to tell you, this is going to be on there. You're hearing me say it first. It's going to be on there. Unless you've already taken this exam and you've seen exam questions like this, you know it's on there. So you just have to spend some time learning those protected classes and you'll do fine. Question number 9. In Massachusetts, a landlord has a legal right to do which of the following? Letter A, charge a late fee when rent is more than 7 days late. Letter B, begin the eviction process once rent is more than 1 day late. Letter C, collect a security deposit equal to 1 month's rent plus up to $500 in pet deposit. Letter D, all of the above. Question number 9. In Massachusetts, a landlord has a legal right to do which of the following? And the answer is... Letter B, begin the eviction process once rent is more than 1 day late. Landlord-tenant, 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 rules and regulations, they will be on this examination, I'm telling y'all. So you definitely want to look through these in any of the sections and any of the texts that you're studying with any of the coursework or any of the providers that you've taken this course with. If you've taken it with us, you know I'm going to browbeat this into your minds, into your mind grapes. You need to know this one for sure. This is absolutely popular style of question, and you want to know that the eviction process can absolutely begin once rent is more than 1 day late. We cannot charge late fees until rent is 30 days late. More than 7 days late, letter A, not correct. We cannot charge any more than 1 month's rent, up to 1 month's rent for security deposit. Pet deposits and all of that stuff are not allowed here in Massachusetts, which therefore would make D, all of the above, also incorrect. Question number 10. Who is responsible for setting real estate commission rates in Massachusetts? Letter A, MAR. Letter B, the Attorney General. Letter C, the Board of Real Estate Brokers and Salespersons. Letter D, the agent or broker and their seller. Question number 10. Who is responsible for setting real estate commission rates in Massachusetts? And the answer is letter D, the agent or broker and their sellers. So, classic. Real estate commissions are 100% negotiable. There are no set federal or state standards as to what we can charge in the brokerage business. It's whatever the market will bear. It's whatever the seller is willing to pay. It's whatever the brokerage firm is willing to work for. And this is negotiated openly. So there are no of these, and none of these entities have anything to do with it. The board of real estate brokers and salespersons have nothing to do with commission rates. The attorney general has nothing to do with commission rates. And MAR, which is the Massachusetts Association of Realtors, by the way, has nothing to do with establishing it. There's best practices, there's standards, there's trends, but none of which have anything to do with setting commission rates. Those are set absolutely by 100% open, free, laissez-faire marketplace. Question number 11. To be eligible to become a real estate broker in Massachusetts, an agent must first, letter A, work part-time under a licensed broker for at least 5 years. Letter B, work full-time under a licensed broker for at least 3 years. Letter C, work full-time under a licensed broker for at least 5 years. Letter D, work full-time under a licensed broker for at least 5 years or complete at least 40 real estate transactions. Question number 11, to be eligible to become a real estate broker in Massachusetts, an agent must first, and the answer is letter B, work full-time under a licensed broker for at least 3 years. So you want to know, what does it take to become a real estate broker? And from salesperson to broker, we want to know sort of what the progression is. The progression is you have to be licensed and be actively connected to a brokerage firm for 3 years. Now, as a matter of fact, the statute reads that you have to be putting in a minimum of 25 hours per week for that 3-year period. And you can do that 3-year period over a 5-year period, just for some clarification. I don't know how in the weeds you're going to get there, but you want to definitely know what does it take, and that's 3 years. So the 3-year idea here, these 5 years, if you look at just this test question, 5 years, 5 years, 5 years, letter A, letter C, letter D. The only one that said 3 years was letter B. So even if the phraseology of the answer here might be a little bit, less desirable in my opinion for it, and sometimes you'll see questions like this in writers, and it kind of makes the cut and makes the grade when it gets onto a real estate examination, I would say that this is the most correct answer no matter what because of the 3 years. And I would go after that, considering that the other ones all say 5 years. Question number 12. The term, quote-unquote, principal in a real estate transaction refers to which of the following? Letter A, the broker's client. Letter B, the buyer. Letter C, the seller. Letter D, all of the above. Question number 12, the term principal in a real estate transaction refers to which of the following? Letter A, the broker's client. Letter B, the buyer. Letter C, the seller, or letter D, all of the above. And the answer is letter D, all of the above. So the principal in the transaction is sort of the party that we are working for. It is the broker's client. That's the party that we're working for. It could be the buyer. It could be the seller in the transaction, known as the principal. So here it is absolutely relevant to pick all of the above in this type of question, just kind of knowing who is the agent, who is the principal, knowing that principal and the word client are interchangeable. Other phrases that use principal, like principal broker, all of those phrases, sorting through those and make sure you understand who is who in the transaction. Question number 13. Which of the following is not true about the requirements of a trust account in Massachusetts? Letter A, at least 2 designated salespersons must have access to the account. Letter B, it must be separate from the managing broker's personal funds. Letter C, it must be managed by a licensed broker. Letter D, its purpose is to hold deposits from real estate transactions until the sale closes. Question number 13, which of the following is not true about the requirements of a trust account in Massachusetts? And the answer is letter A, at least 2 designated salespersons must have access to the account. And again, remember here, we're talking about, really, really subtle things here sometimes. Which of the following is not true about the requirements of a trust account? So in essence, when I'm looking through these answers, if I'm doing this test question, I'm trying to figure out which of these are true. Is letter A true? Is letter B true? Is letter C true? Is letter D true? So you're looking forward to seeing, hey, is this right? Is this correct? Is this factually accurate? Yes or no? So just looking at the other ones, it must be separate from the managing broker's personal funds. Absolutely true. It must be managed by the licensed broker. Yeah, because the broker here has the $5,000 surety bond, which means that the broker manages ultimately the escrow or trust account. Remember also that we can call a trust account an escrow account. It depends on the writer. So this is, again, a very subtle thing, but sometimes because those two phrases are interchangeable, a student might get tripped up and go, what's a trust account versus what's an escrow account? Some instructors may call it an escrow account. Some instructors may call it a trust account. You want to know that they're one in the same. They're just an account that we separate the client or customer funds from our own funds. And in letter D here, the purpose is to hold deposits from a real estate transaction until the sale closes. That is the reason why we have these trust or escrow accounts. All right, so letter A here is the correct answer. Having 2 salespersons access the account has nothing, it's not even true. Question number 14. A seller who opts not to use a real estate broker to list their home still has the obligation to disclose. Letter A, that the home is in a pre-foreclosure situation. Letter B, that the known presence of lead-based paint. Letter C, that there was a pest infestation 10 years ago which was treated and rectified. Letter D, all of the above. Question number 14, a seller who opts not to use a real estate broker to list their home still has the obligation to disclose. And the answer is letter B, the known presence of lead-based paint. All right, so kind of what made it not correct with all of the above. And in letter C again here with the pest infestation, again, it's been a long time. It was treated and rectified, right? So that was a big thing there that kind of, took you away from that one. Even though I would say some students might have been compelled to pick all of the above, which would probably be, my guess, the number one most wrong answer of this, a question like this, where people always err on the side of caution. Be very wary of that, by the way. But a seller who opts not to use a real estate broker to list their home still has the obligation to disclose lead-based paint. Any material defect that could adversely impact the health or safety of any individual or group is you are required to disclose that, which lumps in lead-based paint. So you want to make sure environmental issues always have to be disclosed, even if I elect to not hire somebody in the brokerage community to represent us in the sale of our home. Now, that the home was in pre-foreclosure, the answer is no. That has nothing to do with actually having to disclose that. And the pest infestation thing is kind of on the fence, but I'm going to say that they've kind of stretched it out a little bit. With 10 years, it was treated and rectified. So what if all of them need to be disclosed regardless of anything is this lead-based paint, letter B. Question number 15. A broker who is working to complete a transaction and is bound under Mass General Law, Chapter 93A, but does not represent either the buyer or the seller is called a letter A, dual agent. Letter B, sub-agent. Letter C, facilitator. Letter D, broker associate. Question number 15. A broker who is working to complete a transaction and is bound under Mass General Law, Chapter 93A, but does not represent either the buyer or the seller is called a and the answer is Letter C, facilitator. Okay, so we definitely want to know our agency items. We want to know, the seller's agent, buyer's agent, dual agent, sub-agent, designated agent, and facilitator. And facilitator, they sometimes, depending on the test writer, may call them transactional broker, or they may call them a non-agent. But no matter what, this is a really, really strong definition here in Massachusetts about a facilitator, is a broker who is working to complete the transaction is still bound under Mass General Law, Chapter 93A, but does not represent the buyer or the seller as clients in the transaction. They're both treated as customers. So again, you want to know the definition of what a facilitator is, and this is a really well-written question. I like it. Question number 16. A tenancy at will can be terminated when... Letter A, either the landlord or tenant give at least 30 days notice. Letter B, either the landlord or the tenant gives at least 60 days notice. Letter C, both parties mutually agree to terminate the tenancy. Or letter D, it cannot be terminated before the end of the written lease term. Question number 16, a tenancy at will can be terminated when... And the answer is letter A, either the landlord or the tenant give at least 30-day notice. Now, this 30-day notice must be in writing. Okay, it's written notice here in Massachusetts, not just verbal. But 60-day notice, not correct. Both parties mutually agree to terminate the tenancy. That's you can terminate a tenancy if both parties mutually agree. But what they were really looking for here is the tenancy at will component, and how do we terminate a tenancy at will? And that's 30-day written notice by either party. It's that D is not true. It cannot be terminated before the end of the written lease term. That's not true at all. You can terminate anything if both parties mutually agree to it. But what they were really looking for here is this 30-day notice, and it also must note that it must be in writing. Question number 17. A home built in 2007 with an attached garage must have a carbon monoxide detector, letter A, installed on every habitable level of the home before it is listed for sale. Letter B, present in every bedroom of the house. Letter C, installed at the front of any stairwells and in the garage, but not in the finished basement. Letter D, installed on every habitable level of the home at all times, even if the home is not being sold or transferred. Question number 17, a home built in 2007 with an attached garage must have a carbon monoxide detector. And the answer is letter D, installed on every habitable level of the home at all times, even if the home is not being sold or transferred. So carbon monoxide is a hazardous substance. We definitely want to know a few things about carbon monoxide, one of which is sort of its location and placement. 10 feet from every bedroom, one on every habitable floor at all times, even if the home is not being sold, if there's an attached garage, if there's any fossil fuel burning elements. And you want to also reflect on when and what types of smoke alarms and what is a smoke certification as well. Okay, and there's some subtleties here. You just have to be careful and not pick the wrong one. But habitable level is a very popular phrase in books, so many times people might select A, and some folks might think that, hey, before it's listed for sale, but it needs to just be at all times, basically. Question number 18. In Massachusetts, environmental hazards cleanup is addressed by letter A, the Wetlands Protection Act. Letter B, Chapter 21E. Letter C, Title 5. Letter D, Chapter 151B. Question number 18. In Massachusetts, environmental hazards cleanup is addressed by Letter B, Chapter 21E. So, just want to understand all of these are legitimate things here. All of these answers were legitimate things. We had the Wetlands Protection Act. We had Chapter 21E, which is our Hazardous Cleanup Act. It's sort of our version of what CERCLA is on the federal level. Title V deals with septic and cesspools and inspections there. And Chapter 151B was the Massachusetts Fair Housing Act. Again, all things that are relevant, all things that are real, but the environmental hazards cleanup is addressed here in Mass General Law, Chapter 21E. Question number 19. If an agent has a property listing and another agent from their office is representing the buyer, which of the following is true? Letter A, it is a designated agency relationship. Letter B, it is a sub-agency relationship. Letter C, the managing broker becomes a dual agent. Or letter D, both A and C. Question number 19, if an agent has a property listing and another agent from their office is representing the buyer, which of the following is true? And the answer is letter D, both A and C. Okay, so what they painted here is a classic what is designated agency style question. And what we want to remember is sort of when we're playing designated agency, we're keeping the deal in-house. Somebody has a listing, and that was one of the key phrases, or a listing meaning that they referenced that, hey, a listing means sells, representing the seller. And then somebody else was representing the buyer at that same firm. And what does that do? That makes the principal broker or the broker a dual agent, and that's the classic definition of this. So when you look at these answers, it is a designated agency relationship. Absolutely. Now, some students might just pick A. They needed to read a little bit further because letter C here is also correct. The managing broker becomes a dual agent. So in designated agency, when we are practicing, when there are two parties representing both sides at the same firm, well, then the broker, the managing broker, becomes a dual agent role. Both parties become their client in essence. At the firm, however, there are individual respective agents representing each side. So this is a designated agency relationship, but it is also the managing broker has to become a dual agent. That is a correct statement. Therefore, that's why D was the correct answer here. Review what are your agency types. I'm telling you, they will serve you well. On exams like this, you see them always. And this is an excellent example of a question that details the fine points of what is a designated agency relationship, which are very popular in real practice when you get into the field, by the way, after you get your license. Question number 20. The court's decision in McCarthy v. Tobin established that, letter A, net listings are illegal in Massachusetts. Letter B, dual agency is legal in Massachusetts with the consent of both parties. Letter C, offers to purchase real estate are binding legal contracts in Massachusetts. Letter D, offers to purchase real estate are not binding contracts in Massachusetts until after a home inspection has been performed. Question number 20, the court's decision in McCarthy v. Tobin established that, and the answer is letter C, offers to purchase real estate are binding legal contracts here in Massachusetts. McCarthy is a landmark case when it comes to this particular examination in this topic. And the idea of the McCarthy v. Tobin case is something that we reference inside of our books and materials. You definitely want to know the basics of McCarthy v. Tobin. And the basic fundamental core, like the nucleus, is that offers to purchase, after the end of this case, the McCarthy case, it established that offers to purchase real estate are binding legal contracts here in Massachusetts. Remember, the offer to purchase is that simple, short initial contract that we enter into when we're making offers and accepting offers on a piece of real estate. And then we formally move to the purchase and sales agreement to make sure that everything is sort of finalized and everything is built harder on top of the purchase and sales agreement. But make no mistake, per McCarthy v. Tobin, the offer to purchase, that simple document, is definitely binding here in the Commonwealth of Massachusetts. And you want to know that for your examination. Okay, that was 20 more questions, and I hope you found these 20 questions useful and helpful. Again, really pay attention to some of the fine points of these questions and study those topics that I reinforced during our review of these. I hope they serve you well, and I hope they lead you to passing this section of the exam. Please, respond to us in the chat. If you know someone that can benefit from this, please share this, like and subscribe if you can, because we're always putting out new materials in all kinds of different variants when it comes down to getting your real estate license and some of the foundations and the fundamentals of business and the foundations and fundamentals of real estate property, generally speaking. So it was a pleasure to be with you during this segment. I look forward to doing more like this in the future, and we'll see you very soon. Good luck on your exams.